Conditions of Additional Credit Allowance, Section 910. A taxpayer shall be allowed the additional credit under Section 909, with respect to his contribution rate, under a state law being lower, for any taxable year than that of another employer subject to such law, only if the board finds that under such law, 1. Such lower rate, with respect to contributions to a pooled fund, is permitted on the basis of not less than 3 years of compensation experience. 2. Such lower rate, with respect to contributions to a guaranteed employment account, is permitted only when his guarantee of employment was fulfilled in the preceding calendar year, and such guaranteed employment account amounts to not less than 7% of the total wages payable by him, in accordance with such guarantee, with respect to employment in such state, in the preceding calendar year. 3. Such lower rate, with respect to contributions to a separate reserve account, is permitted only when a. Compensation has been payable from such account throughout the preceding calendar year, and b. Such account amounts to not less than 5 times the largest amount of compensation paid from such account within any one of the 3 preceding calendar years, and c. Such account amounts to not less than 7% of the total wages payable by him, plus the total wages payable by any other employers who may be contributing to such account, with respect to employment in such state, in the preceding calendar year. B. Such additional credit shall be reduced, if any contributions under such law are made by such taxpayer at a lower rate under conditions not fulfilling the requirements of subsection A, by the amount bearing the same ratio to such additional credit as the amount of contributions made at such lower rate bears to the total of his contributions paid for such year, under such law. C. As used in this section. 1. The term reserve account means a separate account in an unemployment fund, with respect to an employer or group of employers, from which compensation is payable only with respect to the unemployment of individuals who were in the employ of such employer, or of one of the employers comprising the group. 2. The term pooled fund means an unemployment fund, or any part thereof in which all contributions are mingled and undivided, and from which compensation is payable to all eligible individuals, except that to individuals last employed by employers with respect to whom reserve accounts are maintained by the state agency, it is payable only when such accounts are exhausted. 3. The term guaranteed employment account means a separate account, in an unemployment fund, of contributions paid by an employer or group of employers who, a. guarantees in advance 30 hours of wages for each of 40 calendar weeks or more, with 1 weekly hour deducted for each added week guaranteed in 12 months, to all the individuals in his employ in one or more distinct establishments, except that any such individual's guarantee may commence after a probationary period included within 12 or less consecutive calendar weeks, and b. gives security or assurance satisfactory to the state agency for the fulfillment of such guarantees, from which account compensation shall be payable with respect to the unemployment of any such individual whose guarantee is not fulfilled or renewed, and who is otherwise eligible for compensation under the state law. 4. The term year of compensation experience, as applied to an employer, means any calendar year throughout which compensation was payable with respect to any individual in his employ who became unemployed and was eligible for compensation. Title 10. Grants to States for Aid to the Blind Appropriation, Section 1001. For the purpose of enabling each state to furnish financial assistance, as far as practicable under the conditions in such state, to needy individuals who are blind, there is hereby authorized to be appropriated for the fiscal year ending June 30, 1936, the sum of $3 million, and there is hereby authorized to be appropriated for each fiscal year thereafter a sum sufficient to carry out the purposes of this title. The sums made available under this section shall be used for making payments to states which have submitted, and had approved by the Social Security Board, state plans for aid to the blind. State plans for aid to the blind. Section 1002. A state plan for aid to the blind must, 1. Provide that it shall be in effect in all political subdivisions of the state, and, if administered by them, be mandatory upon them. 2. Provide for financial participation by the state. 3. Either provide for the establishment or designation of a single state agency to administer the plan, or provide for the establishment or designation of a single state agency to supervise the administration of the plan. 4. Provide for granting to any individual whose claim for aid is denied an opportunity for a fair hearing before such state agency. 5. Provide such methods of administration, other than those relating to selection, tenure of office, and compensation of personnel, as are found by the Board to be necessary for the efficient operation of the plan. 6. Provide that the state agency will make such reports, in such form, and containing such information as the Board may from time to time require, and comply with such provisions as the Board may from time to time find necessary to assure the correctness and verification of such reports. And 7. Provide that no aid will be furnished any individual under the plan with respect to any period with respect to which he is receiving old age assistance under the state plan approved under Section 2 of this Act. B. The Board shall approve any plan which fulfills the conditions specified in subsection A, except that it shall not approve any plan which imposes as a condition of eligibility for aid to the blind under the plan, 1. Any residence requirement which excludes any resident of the state who has resided there in 5 years during the 9 years immediately preceding the application for aid, and has resided therein continuously for 1 year immediately preceding the application. Or 2. Any citizenship requirement which excludes any citizen of the United States. Payment to states, Section 1003. A. From the sums appropriated therefor, the Secretary of the Treasury shall pay to each state which has an approved plan for aid to the blind, for each quarter, beginning with the quarter commencing July 1, 1935, 1. An amount which shall be used exclusively as aid to the blind equal to 1/2 of the total of the sums expended during such quarter as aid to the blind under the state plan with respect to each individual who is blind and is not an inmate of a public institution, not counting so much of such expenditure with respect to any individual for any month as exceeds $30, and 2. 5% of such amount, which shall be used for paying the costs of administering the state plan, or for aid to the blind, or both, and for no other purpose. B. The method of computing and paying such amounts shall be as follows. 1. The Board shall, prior to the beginning of each quarter, estimate the amount to be paid to the state for such quarter under provisions of Clause 1 of subsection A, such estimate to be based on a report filed by the state containing its estimate of the total sum to be expended in such quarter in accordance with the provisions of such clause, and stating the amount appropriated or made available by the state and its political subdivisions for such expenditures in such quarter, and if such amount is less than 1/2 of the total sum of such estimated expenditures, the source or sources from which the difference is expected to be derived. B. Records showing the number of blind individuals in the state, and C. Such other investigation as the Board may find necessary. 2. The Board shall then certify to the Secretary of the Treasury the amount so estimated by the Board, reduced or increased, as the case may be, by any sum by which it finds that its estimate for any prior quarter was greater or less than the amount which should have been paid to the state under Clause 1 of subsection A for such quarter, except to the extent that such sum has been applied to make the amount certified for any prior quarter greater or less than the amount estimated by the Board for such prior quarter. 3. The Secretary of the Treasury shall thereupon, through the Division of Disbursement of the Treasury Department, and prior to audit or settlement by the General Accounting Office, pay to the state, at the time or times fixed by the Board, the amount so certified, increased by 5%, operation of state plans,